Hello and welcome to the 34th episode of Business Litigation TV. I'm your host, Jesse David Eisenberg, and I'm a New York Business Litigation Attorney. And this is the internet's most passionate show about business litigation. Today, I want to get into basic contract terms. All right. As a business litigation attorney, the majority of cases I handle are about breach of contract. So I want to get into, what certain terms mean, but more importantly, just the basics you need to have a valid contract. So I'm going to start with consideration. I've spoken about consideration before, but it's the most important part of a contract, okay? And it's very simple. If you break it down, it's each side to a contract gives and gets something in order to perform the contract. Okay, so the basic example I always use is, let's say you are paying someone $2,000 to paint your home, right? The painting of the home is one person's obligation, and the other person's obligation is paying the $2,000. But in order to get the $2,000, the person has to paint the home, and in order to get your home painted, you got to pay the $2,000. So, see, it's reciprocal. That is consideration. Okay, why are you going to perform under the contract? That's what consideration boils down to. Another term is mutual agreement. So, if you're having a contract, you need to agree on what it is you're contracting for, okay? So, the basic law school example, it's very old, is that these people were contracting for goods, details are a little fuzzy, but goods to come in on a boat, okay? And what they didn't know is that there was two boats with the same name. One boat was coming in at one point in time, another one was coming much later in time. So one party meant boat one that was coming earlier, and the other party meant boat two. All right, they didn't know that they were talking about two different boats. They didn't know that that they weren't agreeing on the same terms, so they didn't have mutual agreement. Now, for a more up-to-date standard, let's say you make an agreement for payment. You're going to give someone goods, and you're going to get paid in January. You're thinking January 2019. Well, the person who is providing the goods, you're selling the goods to, they're thinking January 2020 when they have to pay you. All right? So if you just put January in the contract, you guys don't have an agreement because you haven't agreed. There's no mutual agreement on the term of when you're going to get paid. Another one is competent parties. This is very important when you have a contract. All right? If you're under the age of 18 or someone you're contracting with is not mentally capable of understanding the terms of a contract, all right? There's some mental difficulties there. Maybe they're an adult with a guardian. They aren't capable of entering into a contract, okay? So a 12-year-old kid, not capable of entering into a contract. Just, it's one of the legal terms that and ideas you have to deal with. Doesn't come up too often, though. Another one is you need a mutual obligation to perform. So, let's say you write down on a contract, John Doe is going to paint my house in January of 2019, and he will get $2,000 eventually. Okay, that eventually might not be in there, but you don't have a time of payment. All right, there's not a mutual obligation to perform then, because if you could pay him in 3 years from now, whatever, there's no term for that. There's no agreement of when he's getting paid. Then you don't have a mutual obligation to perform. He's got an obligation to paint the house now, but when are you paying him? So again, there's not a mutual obligation there. Something very basic, you can't have a contract for a crime, okay? If you make a contract, say person X is going to provide me with 20 kilos of cocaine, and they don't, you can't go to court because they broke that contract. Illegal contracts for illegal goods, contracts just for anything illegal, let's say a hitman, something that's not legally allowed. And Just a couple other things to keep in mind. When you're having a contract, you both have to sign it, okay? It's probably also a good idea for both of you to have it notarized, depending on how in-depth it is. You know, if you're doing something for, let's say, $20,000, $50,000, $100,000, let's get the signatures notarized, so one side or the other can't say, that's not my signature. And then, guys, as always, I fully recommend, whether you're drafting a contract or you're signing a contract, hire an attorney to look it over or to draft it for you, okay? Attorneys may be expensive, but litigation is always much more expensive. All right, guys, thanks for listening. As always, take care, and until next time, be well.